Bill for the public hearing, House Bill 1169, with a staff briefing from Ms. Adams.
Thank you. House Bill 1169 relates to two types of mandatory legal financial obligations, which are monetary obligations that are imposed on a defendant convicted of a crime. First, the crime victim penalty assessment. This must be imposed on any adult convicted of an offense in Superior Court, with a few exceptions. The penalty assessment is $500 for a felony, $250 for a misdemeanor, $500 for a felony or gross misdemeanor, $250 for a misdemeanor, and $100 for a juvenile offender who has found to be committed a most serious offense. 100% of the crime victim penalty assessment collected is distributed to the county for deposit into a fund for the support of programs to encourage and facilitate testimony by victims and witnesses of crimes. The second mandatory LFO is the DNA database fee. A biological sample must be collected for purposes of DNA identification analysis from every person convicted of a felony and certain other offenses, and the court must impose a $100 fee in connection with this sentence. The court doesn't have to impose this fee if the state has previously collected the offender's DNA as part of a prior offense. 80% of this fee is deposited into the DNA database account, and 20% of it is distributed to the agency collecting the biological sample. And the State Patrol may use the fees in the database account for the operation and maintenance of the DNA database. Under House Bill 1169, the bill eliminates both the crime victim penalty assessment and the DNA database fee, and provides that upon motion of an offender, the court must waive those fees that were previously imposed prior to the effective date of this act. The bill creates a new crime victim and witness assistance account in the state treasury, which will consist of monies appropriated by the legislature for the purposes of comprehensive crime victim and witness programs. And every quarter, the state treasurer will distribute monies in that account to the counties based on a distribution formula. And counties, again, may use those funds only for the purposes of those comprehensive crime victim witness assistance programs. With respect to the DNA database, that account will also consist of monies appropriated by the legislature for purposes of maintenance and operation of the DNA database, and the State Patrol can continue to use 80% of the funds in that database for that purpose, and then 20% of the funds would go for reimbursing the entity that collected the biological sample. Be happy to answer any questions.
Thank you. Questions for staff? Okay, Vice Chair Simmons, welcome back. Tell us about your bill.
Thank you, Chair Hansen. I miss serving on this committee. Sorry, I have a little cold today. My voice is, I'm losing my voice, but I'm COVID-free, just so you know. For the record, I'm Tarra Simmons from the Best District, the 23rd, same as the chair. Back again for another attempt at eliminating the scheme of monetary sanctions to fund our court system. I want to mention that the Chief Justice Gonzalez spoke about this in the State of the Judiciary this year. Last year, we made a lot of progress with House Bill 1412, but this very important policy was stripped out of that bill in the other chamber. I also want to flag that although it came out of this committee on party lines, I want to thank the good member from the 16th who voted for it in appropriations and on the House floor last year. Also want to say I'm really glad that we have a public defender here on this committee with the new member from the 18th. So I hope that you can share with the rest of the legislature the impact that these LFOs have on individuals long after they've paid their sentence and serve their time, and how they can't vacate their criminal record until they pay them off. And some people are on Social Security disability and can never pay it off, and so they lack access to housing and employment and all these other things. I want to also note for the record that there's no opposition to this bill, because I've worked closely with victims, prosecutors, law enforcement, AOC, and so many stakeholders. And so this is really about freeing up county clerks from having to enforce these debts that they cannot collect on, and instead providing a sustainable source for victim services and the DNA collection. This will free up county clerks to actually enforce restitution against an individual and help victims more, and not have to spend so much time trying to enforce on poor people who can't pay. And with that, I just ask for your support again this year.
Thank you. Question to the Prime Sponsor? Are you nodding in my direction? Okay, Representative Cheney.
Thank you. I guess my question is this would this bill change it to be waivable fees under a Blazina analysis, or would this completely delete those fees? And the reason I ask this, it seems like there might be a dichotomy between Blazina and its progeny and those who can financially be able to do this, perhaps private retained clients and things like that. Thank you.
Yeah, I think this is just getting rid of it for ease and efficiency. As you probably know, under Blazina, you can never waive these two. So even people on Social Security disability that you can't collect on, they still sit there dead forever, and the county clerks continue to send out monthly notices and waste time and money and postage. And so this was actually a deal with clerks and prosecutors, and like, let's just get rid of this scheme on these two mandatories, because these funds are really important. It's important to have victim services, and let's just fund that, because to try and do the math, I mean, I think it's a small amount of people that actually retain counsel and have money. Most of the people going through the system rely on public defense. So it was just too difficult to do the math and figure that out.
Okay, thank you. Let's hear some public testimony, which we're going to start at 1 minute, 30 seconds, because we have a lot of testifiers on this bill, and we have a large bill after this. So, Madam Vice Chair.
Thank you, Mr. Chair. We will start with two people that I understand are remote, Alex Herr and Evan Walker, and then we'll go to a few folks who are in person, Hannah Warner and Brooke Davies.
All right, Alex Herr, please unmute yourself and proceed.
Good morning, Chair Hansen, Ranking Member Walsh, and members of the committee. My name is Alex Herr, and I'm testifying in support of House Bill 1169 on behalf of the Statewide Poverty Action Network. At the Statewide Poverty Action Network, we advance equitable policy solutions for low-income people in Washington State, and our work starts and ends within Washington communities through our semi-annual listening sessions, ensuring both accountability to and guidance by those most directly impacted by the effects of poverty. And it's in these listening sessions over 10 years ago that we heard about the devastating impact that LFOs have had in our communities living in poverty. As a state, we've made meaningful progress in reforming the LFO system, and this body recognized the disproportionate harm that mandatory and non-mandatory fees had on people living in poverty. We support the provisions in House Bill 1169 that would eliminate the last two remaining LFOs that must be imposed, regardless of a person's ability to pay, and replace them with alternative state funding sources. Washingtonians deserve an equitable judicial system that is funded as a function of government, not funded on the backs of those who can least afford it. Thank you for your consideration.
Great, thank you. Evan Walker, please.
Hi, good morning, Chair Hansen and members of the committee. For the record, my name is Evan Walker, and I'm a senior policy analyst at the Washington State Budget and Policy Center, testifying in our strong support of House Bill 1169. House Bill 1169 is a crucial policy that advances racial, economic, and legal justice in Washington because it grants relief to people who qualify as indigent from mandatory LFOs and more reliably funds victims and victim services through the state. Previous and ongoing research show that assessing and collecting mandatory LFOs from Washingtonians who can't pay exploits and saddles them and their families with debt and economic insecurity. And research on collections also shows that this funding scheme is an incredibly unreliable source of revenue for victims, victim services, and recouping court costs. Each year, millions of dollars in LFOs go uncollected, with a small amount of usable revenue raised coming in at a large detrimental cost to the health and well-being of many families across our state. House Bill 1169 is an important answer in addressing these issues by increasing relief from mandatory LFO debt for people who don't have the ability to pay, and it also creates more reliable funding accounts at the state level for victims across Washington. So I urge your strong support in passing this bill. Thank you for the opportunity to speak and for your time.
Great, thank you. Let's hear from the in-person testifiers. Whoever wants to go first.
Good morning, Chair Hansen and members of the committee. My name is Hannah Warner, and I'm an attorney with Columbia Legal Services testifying today in strong support of House Bill 1169. Mandatory legal financial obligations have a devastating impact on communities living in poverty because they must be imposed regardless of a person's ability to pay and cannot later be waived. We support this bill because it eliminates two of the state's last remaining mandatory LFOs, the Victim Penalty Assessment, or VPA, and the DNA collection fee, and replaces them with dedicated state funding accounts. State funding would ensure stable, quality services for survivors of crime. Currently, we're attempting to fund crime victim and witness services in the prosecutor's offices through the collection of VPA fees. With this bill, Washington State would move away from an inequitable fee collection model and come closer in line with the rest of the country in terms of state spending on our criminal legal system. We understand that the Washington Association of Prosecuting Attorneys may have some concerns, and we are open to further discussion on how we can best strengthen the bill to relieve individuals of burdensome debts they simply cannot pay, while ensuring that crime victim services that were funded by the VPA can continue to be properly funded. For these reasons, we urge this committee to support this bill. Thank you.
Great, thank you. Please.
Good morning, Chair Hansen and members of the committee. For the record, my name is Brooke Davies, and I'm here today on behalf of the Justice Action Network in support of House Bill 1169. The Justice Action Network is a bipartisan criminal justice reform organization working with state policymakers from all parties to enact legislation that right-sizes the criminal justice system. We support legislators from all ideological backgrounds to push for smart criminal justice bills that keep communities safe. In this capacity, Jan is proud to support the efforts of Washington state leaders on criminal justice issues for several years now. The goals advanced by this bill are not ideological, they are bipartisan. Republicans and Democrats have come together in states across the country to limit the impact of fines, fees, and restitution in the name of a fairer, more effective criminal justice system. Policymakers in states as conservative as Utah, Arkansas, and Arizona have championed the goal of curbing financial obligations imposed through the justice system. Funding for important victim services should come from a consistent, reliable source. Instead, just 5% of levied LFOs are actually collected in Washington. Funding government, especially victim services, through financial obligations imposed through the court is extremely inefficient and ineffective. In addition to the bureaucratic waste they generate, these fees trap people in the criminal justice system unnecessarily and potentially increase recidivism. Thank you very much for the opportunity to speak. Please support this bill.
Thank you. Let's hear further public testimony. Madam Vice Chair. Vice Chair Entman, please.
Thank you. There was a statement about a EPA fee. Can somebody please define that term?
Let's go with staff on that one. Ms. Adams.
I didn't hear that specifically, but I'm thinking that maybe what was said was VPA fee, which is Victim Penalty Assessment fee that we're discussing.
Thank you for that clarification.
Great, thank you. Let's hear further testimony. Madam Vice Chair.
Thank you, Mr. Chair. We will now go to a remote panel, including David Keenan, Karen Pesey, Kelly Olson, and Nick Jeffries. After that, if you'd like, our on-deck panel is going to be also remote. Anita Condeval, Tyranny Fincher, I'm so sorry if I mispronounced your name, Liz Troutman, and Antonio Wheat.
Okay, I do not see David Keenan, so let's go with Karen Pesey, please.
My name is Karen Pesey. I'm formerly incarcerated. And good morning, Chair Hansen and members of the committee. I urge you to support House Bill 1169. As a formerly incarcerated person owing LFOs, I'm on Social Security, disability, with a very, very limited income. I will never be able to pay off my LFOs. Therefore, these fines will never be paid. I know that there are thousands of other individuals owing LFOs in the same position of very limited income. Paying for these services through LFOs is not a stable method. Most will never be paid. They deserve and require a stable funding source so the victims that really need these resources will be able to access them. I really urge you to support this House bill. Thank you.
Great, thank you. Let's hear from Kelly Olson, please.
Good morning, Chair Hansen and members of the committee. I want to thank you for the opportunity to testify today. For the record, my name is Kelly Olson and I'm the policy manager for the Civil Survival Project. I'm here to testify in strong support of House Bill 1169 to grant relief from mandatory LFOs. I'm formerly incarcerated and know from firsthand experience the burden LFOs place on people as they try to rebuild their lives. Eliminating the victim penalty assessment and DNA fee is an important step to bring relief to many families across Washington state, while also providing dedicated funding to support the services these fees were intended to cover. As you have heard from many today, the research shows that very few are actually able to pay these fees, and these fees disproportionately affect people of color and those already living in poverty. Eliminating these fees and fines would stop the practice of spending dollars to collect dimes and provide a more stable source of funding to provide the victim support services these fees were intended for. It also brings critical relief for those who are unable to pay to begin rebuilding their lives without the heavy burden of this debt following them around for decades, if not a lifetime. I urge your strong support in passing this bill. Thank you for the opportunity to speak today.
Great, thank you. Let's hear from Nick Jeffries, please.
I'm here with the Urban League of Metropolitan Seattle. I help facilitate our records vacating program and interact daily with people who just want to vacate their criminal records to move forward in life. But they cannot do so until they have paid their legal financial obligations. Many of those I work with live below the poverty line, and LFOs keep them there by posing as a barrier to work and stable housing. I am here to say that legal financial obligations are unethical. LFOs unfairly punish poverty and create a significant barriers to success and reentry. Many folks who have served their time are still paying for their freedom. Legal financial obligations should not be used to fund our court systems. And when we use LFOs to fund important county and state functions, we create a sharecropper-like system, one that disproportionately attacks Black, Indigenous, people of color, poor, and queer communities. LFOs can result in a life sentence of debt, subjecting them to warrants, regular court summons, and even incarceration related to missed payments. 2 mandatory LFOs are victim penalty assessments and DNA collection fee, making them be funded by defendants make these processes unreliable and insufficient. If these processes were funded by the state, they would be stable, quality services for survivors of crime. It is time to stop squeezing the fees from the pockets of the most vulnerable. I am in support of House Bill 1169.
Great, thank you. Let's hear from, we're just going to keep rolling through public testimony. I think Anita Kandwal is not here. Let's hear from Tyranny Fincher, please. Fincher, excuse me.
Thank you, Chair Hansen and members of the committee for the opportunity to testify on 1169. House Bill 1169. My name is Tyranny Fincher and I am an education program manager at the Urban League of Metropolitan Seattle. I supervise a zero youth detention, also known as Electronic Home Monitoring Program, EHM. This is a community-led program that provides direct services to meet the needs of youth and families who are involved with or have been on electronic home monitoring. We currently have a caseload of 70 youth. We seek to identify and remove barriers to meet the needs of EHM youth and families that are caused by the juvenile legal system. Legal financial obligations are one such barrier. In my experience, LFOs unfairly punish poverty and create significant barriers to successful reentry. For many, LFOs can result in a life sentence of debt, subjecting them to warrants, regular court summons, and even incarceration related to missed payments. For example, youth across the country are being sent back to detention due to the fact that they are unable to pay their fees. They get out of detention after serving time and they collect more fees, putting them back in the same situation or in a worse off situation. This is doing more harm than good to our youth. We are traumatizing and re-traumatizing our youth by putting them in detention centers, and we're adding fees that they cannot afford. Here's an example of a youth that...
So I'm sorry, I have to cut you off because that's been 1:30, but thank you for being here and thank you for your testimony. Let's hear from Liz Troutman, please.
Good morning, Chair Hansen and committee members. My name is Liz Troutman with Stand for Children Washington, which convenes the Debt-Free Youth Justice Coalition, representing more than 20 organizations as well as directly impacted individuals, speaking today in support of House Bill 1169. The DNA and VPA fees are the only mandatory fees remaining in juvenile court, and they are some of the only mandatory fees remaining in any juvenile legal system across the country. Children under the age of 14 can't legally work in Washington, but can be charged these court fines and fees. More than 70% of incarcerated youth have a diagnosable disability, and nearly 44% of Washington youth in JRA facilities have been involved with the child welfare system. Youth and young adults experiencing homelessness are also overrepresented in the court system, yet courts still charge youth with disabilities, youth in foster care, and youth experiencing homelessness these mandatory fees. Due to structural inequality, Black and Indigenous youth are more likely to be in foster care and to experience homelessness than white youth, and foster and homeless youth are more likely to come in contact with law enforcement simply because they are in care or unhoused. Court fines and fees are not an effective tool of accountability or rehabilitation, and research shows that monetary sanctions actually increase recidivism amongst young people. Lastly, they're costly to collect. We're still trying to estimate Washington cost of collections, but in other states, for example, in Oregon, they spent $866,000 last year to collect $864,000 in juvenile court fees. So we urge you to pass House Bill 1169. Thank you.
Great, thank you. Let's hear some in-person tests. Oh, excuse me. And no, I think that's it, actually. Correct? Madam Vice Chair, who's next?
That is correct. Yes, we'll go to in-person testimony from Russell Brown, and then we'll go back to remote to end with Miranda Calmjoy.
Great.
Good morning, Chair Hansen, members of the committee. My name is Russell Brown. I'm the Executive Director for the Washington Association of Prosecuting Attorneys. I'm testifying other today. And I want to make clear that we are not opposed to the changes that are laid out in the policy. Our concern is that the accounts that are going to be created will be properly funded and properly replace the funds that have been used to provide services for victims and witnesses through prosecutors' offices, as well as properly funding of the crime victim penalty assessment. There was language in 1412 before it was stripped out that provided a mechanism to manually adjust on an annual basis the funding that would be provided. And why this is important: if you provide X amount of dollars this year, if we have another year like last year as inflation cruises, that amount of funding would not be sufficient. And so there was language in there to adjust based on economic factors. We've talked to some advocates, and some of the advocates working on this, we believe we have some language that we could propose to fix those items, but our concern will remain that these funds need to be properly set up. The account needs to be properly set up and funded, but otherwise the policy we don't hold opposition to, so long as it can be properly funded. Thank you.
Great. Ranking member has a question.
Thank you, Mr. Chair. Well, you always have to be careful of the brooms that sweep accounts. Can't do much for you there. But I'm interested in the services you mentioned that are funded by these monies. For myself and for everyone listening, will you tell us a little bit about those services, what they are, and where this money goes?
So in 2018, this body made a change to how the victim penalty assessment was distributed, and that money was 100% designated for prosecutors' offices to create a program that would help victims and witnesses of crime Sometimes those individuals come into prosecutors' offices and they simply receive information about how to get crime victims compensation. So they're a victim of crime, they've suffered a loss, our offices will help provide them, connect them to those type of services. Sometimes those individuals want to provide feedback or participate in trial or in motions. And so our offices will provide an individual who will help explain that process. Sometimes they sit with them, sometimes they help connect them to other services in the community that can provide services as they work through sometimes some awfully traumatic and tragic experiences. Sometimes those individuals will sit during the hearings or during trials with them. They also help to coordinate. In my office, when I had a case going for trial, I had someone who would help kind of be the bridge between some of my witnesses or victims while I was handling, juggling other court-related matters. So that's typically the type of services they're provided, again, to connect to services in the community and then to help be a bridge as they are sometimes involved in that process, and sometimes they don't want to be involved in that process. So it's someone to help them through those experiences.
Great, thank you. Let's hear from Miranda Calmjoy, please, remote.
Thank you, Chair Hansen and members of the committee. My name is Miranda Calmjoy, and I'm a health policy analyst for the State Board of Health. Representative Simmons asked that I share the findings of our health impact review of House Bill 1169. A health impact review is an objective, nonpartisan, evidence-based analysis of a legislative proposal to determine its likely impacts on health and equity. Overall, evidence indicates that this bill would likely reduce LFOs for some people, which would likely improve health outcomes, reduce reincarceration, and decrease collateral consequences. There is very strong evidence that reducing LFOs for some people would improve health outcomes. There is strong evidence that reducing LFOs may reduce reincarceration. There's very strong evidence that reducing collateral consequences of conviction would likely improve access to employment opportunities, housing, and economic stability. There is both very strong evidence that reducing reincarceration and improving access to employment and economic stability would improve health outcomes. It's unclear how reducing LFOs for some people may impact equity for people with LFOs. The full report is available on the State Board of Health's website, and it's been shared with the committee. I'm available to answer any questions.
Yeah, Representative Graham has a question, please.
Thank you, Chair. The question that I have regarding your study that you did you include costs that would be transferred to everyday citizens that haven't committed any crimes? This undoubtedly would result in taxes. We're going to have to tax more in order to be able to pay this. So was there any study done to talk about the families right now that are struggling to put food on the table, gas in their car to get to work? Did that come into the study at all?
Thank you so much for the question. I am going to check in with the analyst who conducted the health impact review, and I am excited to get back to you with the answer for your question.
Great. Okay, thank you very much. That will conclude the public testimony, include the public hearing on House Bill 1169. Let's open the